The defense tried to get your case thrown out during the course of your lawsuit in a motion for summary judgment. And you know what? You won your motion for summary judgment. What happens next? Is it smooth sailing? Do you go automatically to trial? You want to know the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, today I'm shooting video in my house, in my kitchen. It's freezing outside today. It's about 25 degrees, and I had a few minutes to share this great information with you. Okay, so now you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. Your doctor denies all of your allegations. Instead, he turns around and says, "Hey, why are you suing me? I did nothing wrong. You, Mr. Patient, you're the one who caused your own injuries." And then the doctor says, "You know what? Even if I did something wrong and caused you harm, your injuries really are not as bad as you claim them to be." Okay, so now your case goes through the entire litigation process. Finally, after all the discovery is finished, your attorney notifies the court that your case is now ready for trial, and he files a document called a note of issue, which alerts the court to the fact that, hey, your case is technically ready for trial, and that discovery is now finished and completed. So what happens next? What happens next is that the defense wants to do everything possible to try and get your case thrown out before ever getting to trial. And you know what they do? They make a formal written request to the judge. It's called a motion for summary judgment, asking the judge to go ahead and throw your case out. And they have to have a medical expert to support their claim that your case does not have merit. Then we have an opportunity to go ahead and respond to that. And we have to bring in our own medical expert to respond to those papers. Now, after a number of months, the judge will render a decision about whether he agrees with the defense's argument and throw your case out, or whether he disagrees with their argument and allows your case to proceed forward. In this scenario, in this example, the defense has made a motion for summary judgment to make every attempt to try and get your case thrown out before you ever get to trial. And we opposed that motion. We put in papers opposing it, explaining why we have a valid basis for a case and why there are questions of fact that require a jury to answer and not questions of law that requires the court to answer. All right. So now, after many months, after a lot of anxiety, what happens? We finally get a decision from the court. And in this instance, the court agrees with us and denies the defense's request to throw your case out. So you're thinking, that's great, you've actually won. Well, yes and no. What you have won is the defense's request at that moment in time to get your case dismissed. That's what you have won. What you have won is a trip to trial. That's exactly what you've won. You've now won a trip to trial, which means after the judge renders this decision, you know what happens next? You think that your case is going automatically to trial. Well, the answer is it's on the path to get to trial. But there's one other step the defense can take and will likely take to try and throw up another obstacle before you ever get to trial. And what's that obstacle? The defense will likely appeal the judge's decision. And that appeal could last anywhere from a year to 2 years. Can you imagine that? Now, after doing everything possible to try and get your case dismissed, and now after we are successful in convincing the judge that we should be allowed to proceed to trial, the defense wants to appeal that decision and wants to delay things even further. So what happens after that? Once they appeal, they will ask the appellate court, the higher court, to throw your case out, claiming that the judge, the trial judge, made errors of law in reaching his conclusions, and therefore your case should be dismissed. But something else you should know. They will also ask the court to stay all the legal proceedings until the appeal is finished. Now, why is that done? The defense is trying to make everything come to a total halt, come to a total stop. They don't want your case to get to trial while this appeal is pending. So they're basically saying, we want the appellate court to review the decision made by the trial judge, and before you go ahead and make a decision, and before we actually get an answer, we want the entire proceeding to come to a complete and total stop. And you know what we say? No. Everything should proceed forward. There's no reason, there's no basis for this stay, to hold things up. Let's proceed forward. If the appeal takes longer, that's too bad. That's their problem. In most cases, the appellate court is going to go ahead and say, no, this case is going to proceed on track towards trial. We are not going to hold up the proceedings. This case is going to proceed forward, and the appeal will be dealt with as we always deal with all appeals. And at whatever point in time we resolve this appeal, that's what will happen. But the case will proceed to trial. And if it goes to trial before the appeal is rendered, so be it. So why do I share this quick information with you? I share it with you because I have a few minutes to share this great information. It's nice and quiet in the house. It's too cold to be outside today. And you know what? I thought this would help you understand exactly how these types of cases work. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.